SJC-13566 in the matter of an impounded case.
Okay, Attorney Anderson.
Good morning, Brian Anderson for the juvenile appellant. May it please the court. A distinctive feature of the juvenile court is that it has limited jurisdiction. Now, of course, limited by age, but also limited by offense, limited by charge. And the legislature has clearly defined when the juvenile court has jurisdiction, but also when it does not have jurisdiction. The juvenile court does not have jurisdiction over a first offense minor misdemeanor. Now, this court has elaborated on the different paths to arrive at a dismissal as a first offense minor misdemeanor. This case creates another path to dismissal as a first offense minor misdemeanor. Now, it's a quirky path. It's a path that may not arise very often, but it's a path that is rooted in basic principles of jurisdiction. Jurisdiction is not a flexible concept.
If it's not a flexible concept, the court did have jurisdiction up through the trial, right?
Correct. The court had jurisdiction up until the point that the jury determined that it was a minor misdemeanor. Now, in that situation, because it's a minor misdemeanor, we then look to, does the juvenile have any prior offenses that would not make it a first offense minor misdemeanor? So this is the rare situation where the juvenile court it's filed as a felony. The juvenile court has jurisdiction over that felony, whether it's his first felony or his fifth felony, they have jurisdiction. They maintain jurisdiction up until the jury says he is guilty of a first offense minor misdemeanor.
Do you think that jurisdiction is actually the correct concept for this? It's not personal jurisdiction, obviously. It may not even be subject matter jurisdiction, because if it were the second time a juvenile were charged with the same offense, the court would have subject matter jurisdiction. That subject matter is within the jurisdiction of the court. So what kind of jurisdiction is this?
Well, this, I believe, will be subject matter jurisdiction. So the legislature says, the legislature defined where the juvenile court, again, has jurisdiction, where it does not.
Right, so you think it's subject matter jurisdiction over the first minor misdemeanor.
Correct.
But not any other or any subsequent minor misdemeanor.
So what?
The subject matter, why isn't it just authority, statutory authority?
So the juvenile court has the authority to hear essentially anything but a first offense minor misdemeanor. So
Right.
it's a first offense minor misdemeanor.
And therefore they have no authority.
Correct. That's what the situation is. Now, it's odd because the situation didn't arise until the jury gives its verdict.
Sure, so they may lose their authority.
Correct.
Right, I have it may be a purely academic concern about why we call this jurisdiction as opposed to a statutory authority.
But we've called it jurisdiction. We've done this 3 times already.
Correct.
Isn't this controlled by express language in our cases? I'm just looking at footnote 8 in Nick N. If a greater charge proceeded to trial and was not proved, the minor misdemeanor charge would be a first offense subject to dismissal. Isn't it clear this is dismissed and the only recording of this is in mass courts to establish that we now have a first misdemeanor?
Yes, I agree.
So isn't this, I just don't find this that, it seems like we've done this and explain what we're.
I agree. So what I think essentially the jury trial functioned as a Wallace W. hearing. So the minor misdemeanor was proved beyond a reasonable doubt. So now the juvenile gets, he gets the benefit of the dismissal because it's his first minor misdemeanor. Now going forward, jurisdiction has been established.
We keep track of it in mass courts, but we don't keep a record. I'm just trying to understand precisely what occurs now. My understanding is, at least at this point is, okay, the felony, they were perfectly allowed to proceed with the felony. It's been disproven. We now have a first misdemeanor, and the way we have explained that, that means it's kept track of in mass courts, but it's not kept as a record otherwise. Isn't that clear from the 3 cases we've done on this?
Yes, I 100% agree with that. The I guess, difference in what actually happened in this case is that a record was created, a board of probation record was created. So right now, the juvenile has a carry, court activity record information that says jury trial, guilty, quaff, dismissed. That's a record that is available to court, law enforcement, prosecutors going forward. That's not what the legislature contemplated. So what the legislature contemplated was, you get a first shot, you commit that first offense minor misdemeanor. It's noted in mass court, so the court is aware this juvenile already has a first offense minor misdemeanor, jurisdiction has been established, but there's no other record
So
of it.
what do you want to have happen exactly? I'm just trying to make sure I understand what you want to
What I think should happen is that the case should be dismissed as a first offense minor misdemeanor, and the notation is made in mass court that he has had the benefit of a dismissal first offense. I'm not exactly clear. There's a distinction between dismissal as a first offense that has without a Wallace W. hearing versus one that has gone to a Wallace W. hearing. Essentially, this jury trial functions as that Wallace W. hearing to establish jurisdiction so that if there is a subsequent first offense minor misdemeanor, trespass, disorderly conduct, the court...
But it seems like sorry.
No, please go ahead.
It seems like the only dispute is what should happen to the court records of this case, meaning that it started as a felony and ended up as a first-degree murder, and what happens to that documentation? Is that right, or am I misunderstanding?
May I ask a follow-up question? It may be...
Yes, so I think it should be noted in mass courts that it was a first offense, dismissed as a first offense minor
Part's
misdemeanor.
the easy part.
Yeah.
I think the harder part is the court records themselves. Do they just disappear, or what happens?
No, I mean, my understanding is that the court has a record that the minor misdemeanor has been proven and jurisdiction has been established going forward, so that if a subsequent complaint for a minor misdemeanor was filed, jurisdiction has been established, and there's no need to, notify the Commonwealth that we need to have a Wallace W. hearing to establish jurisdiction.
I'm wondering, try the following on for size and see what you think of it. We would need to vacate the sentence,
Correct.
remand with an instruction that the minor misdemeanor be dismissed on jurisdictional grounds.
Correct. Dismissed as a
And
first
there's nothing
offense.
that happens with respect to the acquittal on the greater offense.
I mean, I think so, yes.
Okay.
Again, it's a quirky situation. I think the, appropriate thing in mass court, how it's noted.
It was
in the,
charged and there was a jury verdict. There's really nothing, do you think that there's something we could do about that at this point?
No, I think really what the court can't change the fact that he was charged with
And
open and
acquitted.
grossly lewd and lascivious behavior.
So is what I just recited the remedy that you would be looking for as a result of this appeal?
Yes, so I just want to make sure we're on the same page.
Right,
So
we're
it's
trying to understand what your position is with respect to the remedy.
vacating the sentence, vacating the sentence of a continuance without a finding, dismissing the case as a first offense minor misdemeanor. And then however the court notes it, the juvenile court notes it in mass courts so that the first offense minor misdemeanor has been proven, that's how it should end. And then,
But you're still not getting to Justice Kafker's point, what I still share. Okay, we're talking about two very different things. I'm not talking about how it's noted in mass courts. You're mentioning what happens on the CORI, the External Board of Probation, the Commissioner of Probation's records, okay? That's what I'd like to get to, because they're not a party. I don't even know if they have a position on this. But what happens in a situation like this, where now we say there was no statutory authority in the first place, but yet it's already noted by virtue of the arraignment of that charge. Because ultimately, following your logic, this was the first strike that the legislature intended for no one to know about outside of the internal ecosystem of the Massachusetts court system. So in terms of your remedy, is there something else that you're looking for us to direct the commissioner of probation to do? That's what I'm interested in.
No, so I understand the question. And I can give you my opinion how I would plan on handling it. I would do a motion to expunge in juvenile court.
That's what I was going to ask.
So I think
if that's the remedy.
I think I would have to do a separate motion to expunge in juvenile court based on the expungement statute. I don't, I'm not asking this court to say expunge it. I mean, I'm asking for this court to say dismiss it as a dismiss it as a first offense. I believe that would then give me the remedy of going to ask that it be expunged in the juvenile court. Because, a dismissal as a first offense.
Can I just ask, because I have the exact same concern as Justice George, but I'm wondering whether you can go one step further, though, which is, the legislature did not want any record kept of first misdemeanors, whatever they're called, these minor misdemeanors. Does it, I just don't know, but I understand the expungement remedy, but I'm wondering whether you even need to go there. But I have the same concern Justice George's, which is it's just not clear.
So I think again, the remedy that this court could give is an acknowledgement that it should be dismissed as a first offense minor misdemeanor.
I'm just looking at footnote 8, okay? I'm looking at footnote 8 in Wallace W. When such a charge is dismissed as a first offense, record keeping regarding the juvenile shall therefore be limited to mass courts. The court's internal record, the creation of the internal, meaning we don't want anything in the Cary or the other places for these kids. And that's my question, is do you need even to go to expungement?
The record exists right now, so I have to do something to make it disappear.
Right.
And I think
But you're
that-
not asking this court to do that in connection with this case. That would be your second step. is
Yeah,
what
I mean,
you're saying.
I don't know that the court, has authority to order expungement as well, because I think.
But
there's
it's not what you're currently asking for.
I'm currently asking the court to dismiss it as a first offense so that gives me then the ability to follow the expungement statutes to
Right,
ask for
and
it
to
to
the
be
extent you might
dismissed.
have issues with that, that would be a separate
Correct.
appeal.
So I'm looking at it as it's two steps. The first step is dismiss as acknowledgement that it should be dismissed as a first offense minor misdemeanor, and then return to juvenile court to say, this is the finding, these are the this is the expungement statute that allows me to seek expungement. I think that would be the, appropriate way to go about it.
Where is your evidence or any facts to support the proposition that the Commonwealth will overcharge people, given that this charge was supported by probable cause, to get around the statute in the jurisdiction?
I mean, I don't know that.
You said it in your brief.
Well, I don't know. What the jury did is they protect against an overcharge. So.
Was this charge supported by probable cause?
Yes, it was supported by probable cause. I mean, I was the trial attorney. I evaluated the, police report and the facts. I didn't file a motion to dismiss because I believe it was supported by probable cause. And then we get to the different standard, is it proved beyond a reasonable doubt? The same standard applied in Wallace W. is the first offense established beyond a reasonable doubt. And the jury found that.
But you make this sweeping allegation, essentially, that we have to do this because the Commonwealth is just going to overcharge people to get around Wallace W. in the statute.
I don't know that I made that in my brief. I mean, it may have been the amicus brief.
Maybe it's the amicus
Yeah, the amicus brief. I mean, I don't have any data to support that, the Commonwealth is consistently overcharging in order to get jurisdiction because it's a felony versus a minor misdemeanor. What I think that the charges here were supported by probable cause. I did not file a motion to dismiss. And I think the jury ultimately, made that decision that, no, this is not the felony. So the jury, in essence, protected against an overcharge. In a Wallace W. hearing, you could have the judge protect against an overcharge by deciding it beyond a reasonable doubt. Probable cause is not the standard. It's beyond a reasonable doubt. So I think, those protections are built in, to the system. And I see my time is up, so I will rest. Thank you.
Very good, thank you. Okay, Attorney Wakoni Jane.
Good morning. May it please the court, Kristen Jang for the Commonwealth. This case was presented as a subject matter jurisdictional issue, I think appropriately based on this court's precedent, particularly in Nick N., which reached the question of when this issue can be raised and whether it can be waived at any point. And clearly, because this is an issue of subject matter jurisdiction, it cannot be waived. However, the legislature clearly conferred jurisdiction on the juvenile court over cases in which, based on the application for criminal complaint, a felony or major misdemeanor charge is supported by probable cause.
Would you agree that, based upon the statute, after the jury comes back with a lesser included offense, the juvenile is no longer a delinquent child?
I think whether or not the juvenile is a delinquent child would have to go back to the complaint, because whenever we're looking...
Well, if we go to the definition of delinquent child, it's in section 52, you would agree that this juvenile no longer meets that definition?
It's true that that child no longer meets the definition, but when we're looking at questions of jurisdiction, I was unable to find any precedent showing that, based on the disposition of the case, determines jurisdiction.
Well, jurisdiction can be raised at any time, so a
That's
court
true.
can have jurisdiction initially and then lose it somewhere along the way.
That's true. That's very true.
Not
And
court.
here, the delinquent child is defined as somebody who commits, the various offenses and not a minor misdemeanor. And here, the jury said minor misdemeanor.
That's true. But again, I was unable to find any sort of precedent showing that the final and ultimate disposition of a case can affect subject matter jurisdiction. So, for example...
Do you need one? I mean, if you're following the math of Justice Wendlandt and saying that subject matter jurisdiction can be lost at any point, it's not waived, so why do we need a case to say at some point if there's an adjudication where he's no longer a delinquent child, the court no longer has statutory authority? Why do we need a case to say that when it seems to be pretty self-evident?
Well, I'm not sure. So, for example, if the jury came back not delinquent, I don't believe that means that the court doesn't have jurisdiction over this child. It's just that's the ultimate disposition in the case.
But that's another case. I'm talking about this case.
Sure.
So in this case, is there any real debate that once the jury verdict came back, that's it for at least this case, this child in this court?
I don't think so. I do want to clarify. I don't think this court has reached this particular issue. So I do want to go back to a comment that was made on footnote 8 in Nick N.
Mm-hmm.
So in that prior case, I do want to clarify that that involved a major misdemeanor, I believe, or a felony, and a minor misdemeanor that occurred subsequent. So it was two completely separate instances. So I believe this is the first time that this court has reached this particular issue, that it was charged as a felony and came back as a lesser included.
But isn't this case even easier then? Because it was one act, and the result is a minor misdemeanor. What do you want to have happen? I'm just trying to figure out what the Commonwealth wants.
The Commonwealth is seeking for the juvenile court to maintain jurisdiction over this case in order to
For what purpose?
to sentence on the charge that the jury ultimately came back
How
with.
would that be consistent with the Criminal Reform Act?
It's consistent because there was probable cause to support a felony in this case. So based on...
We've rejected that, we rejected that in Wallace W. Probable cause is not enough. It's enough to get you started, but once it's proven this is a minor misdemeanor and you can't sentence on it. I I mean, I just don't get what you're going to accomplish.
Well, the conduct at issue, there was probable cause to charge the felony. So in Wallace W., it had to do with more minor misconduct. And I don't think the legislature intended for cases charging more serious misconduct to go to trial and then have the court lose jurisdiction based on the disposition that either the jury or the judge comes back with. This also prevents...
If you had originally, if the Commonwealth had originally charged both the greater offense and the lesser included offense, so from the start, what would have happened with respect to the lesser included offense? It would have gone to a Wallace W. hearing, right?
Well, in this case,
In other
because
words,
it's
if
the same,
from the start you had,
right, because it's the same incident.
yes, what would have happened in your view?
In my view, I would have to go to the procedural rules. So the application would come before the clerk. The lesser included would have to be dismissed at that point because there's no prior record.
Okay, so as soon as the Commonwealth suggested to the judge that there would be a need to charge on the lesser included offense, why isn't that not, and then the judge does so instruct the jury and the Commonwealth doesn't object, why is that not the functional equivalent of what I just hypothesized? In other words, it's almost like the functional equivalent of amending the charges so that both charges are now in the case.
I understand the hypothetical,
Okay.
but also if the juvenile court loses jurisdiction, if there's an adjudication on the lesser included, did the juvenile court even have the authority to instruct in the lesser included? If
Maybe
they did-
not. I'm
Right.
saying it
That's-
might have been as soon as the Commonwealth interjected this possibility into the case, or maybe at the latest, once they did not object to the judge instructing on that, it seems to me that it's at that point that there needs to be either a Wallace W. type hearing to determine whether that's the first minor misdemeanor with which this juvenile has ever been charged, or what happened here, which is what your brother is calling the functional equivalent of a Wallace W. hearing, where we determine it was the first one and he was adjudicated delinquent of it. But at some point in there, it seems to me that the Commonwealth has precipitated in some way the question about whether there's jurisdiction over that charge.
Well, the issue here is that the juvenile requested the lesser included. So
Right.
So
It
it would be
was-
difficult for us to say that he wasn't entitled to it if his defense was,
Sure.
you know, this was the lesser included, based on how the victim's testimony came out. So this is why, because this is raised as a jurisdictional issue, it becomes very complicated, because then does the court even have the ability to instruct on the lesser included? if they
Maybe
never
not, but
had-
then why does that, so how does that help you, though? If that's true, how does that help you in this case?
Because it means that the court still has jurisdiction even if the jury comes back with the lesser included.
Well,
So
the
they
judge
have-
has an obligation to instruct on the lesser
Right, so
included.
that's what makes this very complicated.
Well, then you get your Wallace W. here, and like it or not.
Okay.
I mean, it's not the most efficient, I mean,
Sure.
to use your, obviously, to have a trial
Yes.
and through all the litigation and discovery, it's not we always talk about judicial economy. This would be the complete opposite of that.
Well,
But
sure, and I-
nevertheless, you know, it makes everybody have to be a little bit more careful about what they do on the charging, the applications when they come in. It just makes everybody have to pay more attention, doesn't it?
Sure, I also want to raise to this court that the victim testified in this case. So it could come down, and I think it did in this case, to just how the victim's testimony came out, what the jury decided to do with that testimony. So I do want to raise the fact that this is going to mean that a victim potentially multiple victims, potentially children, would have to come in and testify, and then the court would ultimately lose jurisdiction if it comes out a particular way.
And so what? What's your point? I guess I'm trying to figure
I'm
out.
just
Because
raising
the
the-
legislature has decided that children deserve a second chance. And that's what all the jurisprudence about, that's what the statute's about. And, you know, yeah, there will be lost resources expended, unfortunately, as Justice Georges points out, in getting to this final result. But the policy decision has been made by the legislature that children deserve a second chance.
Sure, for
you know,
minor
in terms of weighing, you know, which is worse, the legislature has already said we want to give children the second chance. So if it takes more time to do it, and a jury needs to be impaneled, so be it.
And just in connection with that, I think you argued that the legislature didn't intend for this outcome.
Yes.
Where do you get that from?
From all of this court's prior decisions discussing the intent to prevent cases moving forward on minor misconduct, or
So once it's already left the gate, then it has to keep going? I don't understand that.
well, it's
Right, like if we made, oops, we shouldn't have let this one go, it turns out, yeah, I don't understand your logic there.
all of this court's jurisprudence has discussed a second chance for minor misconduct. This was, again, and I'm sorry to repeat myself, but there was probable cause for a felony in this case.
But ultimately, it turned out that it was a misdemeanor, right?
Right.
At a higher quantum of proof.
That is correct. But I'm not sure that the legislature intended for the victim to come in and testify. And we're not sure why the
Or
jury...
probably for the defendant to go through this entire jury trial, right? So I guess, I'm just confused as to the point of the witness testifying. I think the legislature wanted it to be determined ex ante. In this case, everybody had to go through an entire jury trial to get to the result, which is that this child gets to a second chance.
Sure. I just want to emphasize that I do not believe that the legislature intended for us to look beyond the application for criminal complaint when we're determining whether
Already been
there's-
that, we've been
Sure.
through that, and you've lost that battle previously, right? So, again, I'm coming back to your last thing. You seem to want the judge to sentence on this, even though it's a first offense minor misdemeanor. That makes no sense to me. I just don't know why you keep pushing that point. Tell me why that's consistent with as Justice Wendland said, the legislature wants to give these kids a second chance. So what's the point of sentencing when you can't sentence them to anything and it's going to be expunged probably? Well, what are we doing?
Well, I do think the legislature, in terms of looking at the type of conduct, especially that's at issue here, I'm not sure that the legislature intended for the juvenile court to completely lose authority over a kid like this.
I get it. If the jury had come back and said this kid did the felony, the legislature wants him sentenced and punished. But the jury didn't do that. It came back with the minor misdemeanor.
I'm sorry,
I think we may be talking at cross purposes here, perhaps. Maybe I'm mistaken, but hasn't the juvenile already completed the sentence?
Yes.
Okay.
and would you agree, as far as legislative intent goes, we don't know one way or the other whether or not the legislature contemplated this unusual circumstance,
That
correct?
is true.
But the only thing we do know is that the legislature intended that people that are first offenders for minor misdemeanors not be found to be delinquent children.
Yes, that is true.
Can I ask you a question about expungement? Is that, your opposing counsel had suggested that would be a second step should you lose on appeal. Do you agree with that?
To be quite frank with you, I'm not as well versed in the expungement rules, but I would assume that that would be the next step. Yes, if the sentence is vacated and it's there's some sort of judgment that this is a Wallace W. first offense, yes, I would assume that that would be the next step.